Hi and welcome back to another video on A-Level Law on the OCR spec. We're going to be looking at consideration today under contract law. And you need to know three things. You need to know the definition and rules of consideration, the AO1. You need to know the application to a scenario, the AO2, and also how to evaluate consideration, the AO3, essentially how to write an essay on that topic. The definition of consideration is that both parties must exchange something, as the law requires a bargain, not a gift. I.e., you can't, if you're not offering anything, if you can't do something for free and expect that to be a contract, essentially, both parties have to offer something. And we can see that definition from Karivi Misa in 1875, which gives a very complicated definition. You don't have to know it in full if you know the sort of rough layman's terms for that, but that gives the sort of definition of consideration. There are 6 rules of consideration that you need to know, although I would emphasise that the last one is really only relevant to an essay, so it's worth knowing for an essay because it's a good essay point, but nonetheless it probably won't be that relevant to a scenario if at all. So what we're going to do is work our way through these 6 rules, and these rules you need to understand and be able to apply these to a scenario as well. So I've split them out into 3 here, so 3 on each slide. I'm going to work our way through from left to right. The first rule is that consideration need not be adequate, but must be sufficient. The idea is that the courts do not care about the equality of consideration, i.e. what is being exchanged in terms of the value of those things, as long as both parties have offered something of nominal and real value. I.e. if I want to sell my iPad, even though it's worth £500 for £5 to someone, they're giving me £5, I'm giving them an iPad, both of us have exchanged consideration because we've both offered something. What the courts don't care about is the value that, okay, that's a bad bargain for me because I'm selling it for £5 when it's actually worth £500. That's my fault, not the courts. So the courts will basically say you have offered sufficient consideration. It might not be adequate in the fact that it's not worth you've not got what it's really worth, but the courts don't care about that. They're not interested in bad bargains. What they're interested in is have you offered something. And you can see this in old rules like the peppercorn rule where you could live rent free practically, but you offered a peppercorn or a penny nowadays instead per year for rent. And that's because you can't give it for free, otherwise that's not a contract. So even giving something like a peppercorn or a penny that has a real nominal value, and therefore that's sufficient to be consideration. Again, it might not be adequate, but doesn't need to be adequate. We can see that in both cases, Thomas v Thomas and Chappell v Nestle. Thomas v Thomas, they were offered rent for I think £100 a year. At that time, it was not as much. It was obviously a lot more than £100 worth today, but not equivalent really to what you would pay for rent in those times. And they tried to evict her and say, well, you haven't offered consideration, and the court said, no, she has. She's offered £100, and okay, that might not be enough, that might not be adequate, but the court don't care. She has offered something. £100 has value, and therefore that's enough. I think it might have even been £1. It's worth checking that case. It wasn't a lot. In Chappell v Nestle, again, the agreement was that you could send in chocolate bar wrappers and get a discount price off a record. It was basically Nestle worked out it was a bad bargain because they were going to lose loads of money on this, so they tried to say that giving wrappers in wasn't good consideration, that wasn't something that could be exchanged. The court said they are. Wrappers have a nominal real value. It might be virtually nothing, but they do have a technical value, so therefore both parties were exchanging something, therefore there was a contract, and therefore they had to follow through with their promise and do what they said they would do. So basically, some of that rule is that you have to exchange something, but the courts don't care what it is. There is a debate about whether love and affection can be good consideration or not, whether that can count as consideration. They call that good consideration if it does count as consideration. White v Blewett said no, and Ward v Byam said yes, essentially. So there's just a bit of inconsistency there. Really good points for an essay that I'll draw on later. You don't really have to know the facts too much for both of those cases, but just know that they had different outcomes, so there's some inconsistency there. Moving on to the second rule, past consideration is not good consideration. The basic premise here is you can't exchange something you've already done. So if you do something without the expectation that you'll be paid for it, so you're essentially gifting it, you're essentially doing it for free, and then someone afterwards offers to pay you for it, you can't enforce that they pay you because that wasn't a contract, because you did it for free and then they offered. If you want to be paid for it, then you should make the agreement before you do the work to be paid for it, if that makes sense. And that's what happened in R.V. McArdle. She did some work on a bungalow. They then offered to pay her for it once she'd done it. They then didn't pay her. She tried to say, well, you have to pay me. No, they don't, because there was no agreement to pay her in the first case. They were just offering that afterwards. You can't exchange something you've already done. So she didn't offer any consideration for that contract when in exchange for the money. because she'd already done it. You can't exchange something you've already done. She should have said to them, will you pay me to do it, and then done the work. So you've got to be really careful there. There is an exception to that rule, which is an implied promise of payment. So unless there was an implied promise of payment, so it was implied that if you did that work you would get paid, that is an exception, and that would mean there would be good consideration. So in R.E. Casey's patent, he was doing some work on some patents. It was implied, it wasn't agreed that he'd be paid, but it was implied that he'd be paid. He did the work, then they said they'd pay him, and then they wouldn't. And then they didn't, in fact, so he said, well, you have to pay me. And the court said, well, actually, you do have to pay him, because it was implied when he did the work that you were going to pay him. So it's a bit complicated what I've said there, lots of things. But basically, if it's implied, if you do the work past tense and then there's an agreement to pay you for it, and then they don't pay you for it, but it was implied that they were going to, then when you did the work in the first case, then they do need to. Similarly, in Lampley v Braithwaite, he went and got a pardon for a guy to not be executed. He brought it back. The guy said, oh, thank you very much, I'll give you some money for that, and then didn't. So again, it's past tense. He'd already done the pardon. He should have said, I'll go and get the pardon if you pay me this, but he didn't do that. He went and got the pardon, and then afterwards there was the agreement to be paid. So it's really careful you get the timeline right here. In this case, they said clearly it was so important in saving this guy's life that clearly the guy thought he was going to get paid for getting the pardon. It was implied that he was going to get paid, so therefore the guy did have to pay him. So just be careful there, and I illustrate that in a scenario later on for you to see. So have a look at that further on if you're not quite sure with that, how that exception would apply. The third rule is that consideration must move from the promisee. All that simply means is that a person cannot sue or be sued under contract law unless he or she has provided consideration. And that's central to the idea of privity, which is another topic you have to understand under the OCR spec. And you can see this in Tweddle v Atkinson. Two dads made an agreement to pay some money to a couple. The agreement was between the two dads. One of the dads didn't pay the money because I think he died, or he didn't pay the money either way. So the couple tried to sue to get that money, but of course they can't sue because they didn't offer consideration. The agreement was between the two dads. Both the dads offered consideration. The couple were just benefiting from the contract. So in essence, they weren't able to sue because they didn't offer consideration. So again, that comes up really key, and this case comes up again key in the idea of privity. So if you learn privity, you'll understand that rule a bit more. The fourth rule, as you can see the last three here, is performing an existing duty cannot be the consideration for a new contract. So what that essentially means is you can't exchange something that you are already legally required to do, either from a legal requirement, as you see in Collins v Godefroy of a summons, or perhaps in Stilk v Myrick of a contract. So if you're already contracted to do something, you can't offered nothing more apart from doing that in exchange for more money, essentially. And you'll see that as we go through some of these cases. So in Collins v Godefroy, he was summoned to court, a police officer, so he had to go, he was legally required to go, and someone offered him some money to turn up. They then refused to pay him, and he took him to court and said, you have to pay me that money, and the court said, no, they don't, because what were you offering? You weren't offering anything. You already legally had to, you had a pre-existing duty. You can't exchange that for extra money. So they didn't have to be paid. They didn't have to pay him for that. Equally in Stilk v Myrick, their contract, so they worked for £5 a month on a ship, and their contract said you have to help out in emergencies and things like that. Two of the crew deserted, and the captain said, well, if you all of you help do those your own shift and a little bit of their shift as well, I'll split the wages with you for those two people when we get back. He then refused to do that, so they took him to court. And again, the court said, no, you don't, because in your contract it says you have a duty, a pre-existing duty to help out in emergencies. So what are you offering extra for this extra money that you were supposedly going to pay? Nothing, because it's already a pre-existing duty, and that can't be consideration for a new contract. There are two exceptions to that, though, which are extra element and commercial gain. We'll start with extra element. Extra element is if you are doing a pre-existing duty but you're adding an extra element to it, then that actually can be good consideration. So in Glasgow Bros v Glamorgan County Council, the police force were brought in to help in some protests and strikes around a mine. And the mine owner said, well, I'll pay you some extra money if you stay on site as well and help protect, because it's obviously happening all the time. If you stay on site as well, that would be brilliant, and I'll pay some extra money. He then refused to pay him the money, so the police took him to court, and they said, no, Well, sorry. So here's the pit owner, the mine owner said, "Well, your job is to protect people. That's your pre-existing duty. So I'm not paying you any extra money. You haven't offered anything new." But the court said, "Well, actually, they have in this case. There's an extra element because the police wouldn't usually be required to stay on site. So that therefore is an extra element that the police are offering on top of their pre-existing duty of helping people and protecting the public. So therefore, they are entitled to the extra money." Equally in Hartley v Ponsonby, which is very similar to Stoke v Myrick, they were working on a ship. In this case, almost half the crew deserted, not just two, and that made the voyage incredibly dangerous. And therefore, the fact that it was much more dangerous now and they were doing a significant bigger proportion of work meant that actually they were offering an extra element on top of their pre-existing duty, but instead of on top of performing an existing duty. So they were entitled to be paid the extra money in that case, in contrast to Stoke v Myrick. In terms of commercial gain, if the party is making a commercial gain from the new agreement, then sometimes the court will also say, well, actually, you do have to pay them the extra money then. So, and you'll see that in a scenario on the O2 in the next couple of slides on this. And that comes from the case of Williams v Roffey, a really complicated case, but essentially one party was benefiting financially from agreeing were agreeing for this other company, this Carpenters, to do the work that they'd already signed and said they would do in another contract. And they were going to pay them extra because they couldn't finish it on time. So under the normal rule, they were already, they had an existing duty to do that work, but they wanted more money for it. That wouldn't be okay. But because the company was actually making a commercial gain from this, they said it was enough in consideration. Quite a complicated case, so I wouldn't worry too much about explaining the facts and stuff. Just stick to the idea that in that case they were making a commercial gain and that was an exception to the rule. And again, you'll see that clearly laid out in a restaurant example later on in the O2. The fifth rule, consideration may be found where contractual duties are owed to a third party. Basically, what that means is you can charge multiple parties to do the same thing as these are different contracts. So what that means is, for instance, if I was a tutor and I charged a student £20 for an hour tutoring session, and another student said, well, can I tune on that as well? I could also charge that other student £20, even though I'm doing the same session. And the idea is there because they're third parties to each other contracts. Like the contract I have between Barry, one of the students, and Sally, the other student, they're two different contracts. Although I'm offering the same thing, they're both third party, so therefore it doesn't make a difference, basically. In Scotsman v Pegg, a man was paid twice, basically, by two people to transport some coal and unload it, and one person found out they were obviously being paid, the guy was being paid twice, so he didn't want to pay him, but of course the court said, no, you do, because actually that's two separate contracts, so basically do your research first before you offer to pay someone. Make sure they aren't already being paid to do it. Similarly, in Shadwell v Shadwell, a guy agreed to marry a lady, his wife to be, and then someone offered to pay him money to do it, not knowing that he'd already agreed to do it. But of course, that agreement was with someone else, so he did have to pay the money in the end. Quite a complicated rule, that one, but it's worth having an awareness of. Finally, and this is really only relevant to an essay, it's quite specific. Basically, it's called a promise to accept part payment of a pre-existing debt in place of the whole debt is not consideration. What that means is you can't accept part payment of a debt to close the debt. So if someone comes along on the day that owes you £1,000 and says, can I pay you £500 and then just close the debt, would you accept that? You can say yes, but the next day you can continue to chase them for the remaining £500 because that contract is not valid. And that you can see that in both Pinnell's case and Folkes v Beer. I wouldn't worry about the facts of both of those. That is basically what happened. There are two ways around that. One is the principle of accord and satisfaction, and in fact you can't accept money, but you can accept goods or services of a lesser value to close a debt. So if someone owed you £1,000 and they offered you a £500 card to close the debt, that would be sufficient, but they couldn't offer you £500 in cash. That wouldn't be sufficient, which is a bit of a strange rule really, but that is the rule. Equally, the courts came up with promissory estoppel in 1947 from the case of Central London Property Trust v Hightrees House, and it's an equitable doctrine, meaning it's based on fairness. That's what equitable means, and it's the idea that it stops you going back on your promise. Once you've made a promise, you can't go back on it. So in Central London Property v Hightrees, during the war, a landlord said, well, I'll give you half rent to stay in these flats, because obviously everyone was leaving London and didn't want to live in flats during the bombing and the Blitz. So he said, I'll charge you half rent instead. After the war, he then said, actually, no, I want the full rent. And under the actual rule above, he was able to do that. but that seemed really unfair, so the court established this idea of promissory estoppel and said you can't go back on your promise. The problem with that is that, and you'll see in the 803, is that has basically overruled the entire law of consideration that we've just learned, because basically you don't have to worry about consideration, you simply just say promissory estoppel, they can't go back on their promise, which I'll illustrate more in the 803 in a bit. So the courts are now actually moving away from using promissory estoppel where they can, and both in RE Select Move and D&C Builders v Reeves, they said, well, the person didn't act fairly, and because promissory estoppel is an equitable doctrine, they can't use it. So in terms of AO2, in terms of applying this to a scenario, what you need to do is identify what is being exchanged between the two parties. And there might be multiple instances of exchanges in a single scenario, so be careful with that. You might have to deal with several different issues. There probably will be, to be honest. So the first thing is identify what is being exchanged to these parties. You then need to identify the most relevant rule of consideration and apply that rule, considering any exceptions and what both parties will argue, and then come to the conclusion as to whether whichever party they're asking you did offer good consideration or not. So, for instance, if Sally agrees with Mary to provide her cafe venue for free for Mary's Christmas party, you'd apply that in a similar. And then the question was, did Mary offer good consideration? You'd say Sally is providing a venue, a service, and Mary is not providing anything as she is getting the venue for free. The most relevant rule, therefore, is consideration need not be adequate but must be sufficient. Mary is not providing sufficient consideration as she is not providing anything of real or nominal value. Therefore, if she hasn't offered anything, the rule is for consideration is both parties must offer something. Therefore, Mary is not offering good consideration. And remember the rule that the law requires a bargain, not a gift. That's a gift in that case, isn't it? In terms of past consideration, is no consideration. Look at the scenario here on the left. Janet, an artist, tells her in-laws that she will decorate their lounge before they sell their property. Janet decorates the room. Her in-laws sell the property and tell Janet they'll give her £500 to thank her. 2 months later, they have not given Janet the money and refused to when she asks. So in terms of what's being exchanged there, Janet is offering the work she's already done, in the past tense, the decoration, as she's already completed it, in exchange for £500 from her in-laws now. The most relevant rule there is past consideration is not good consideration. Janet, in that case, is offering work she's already done, which you can't under contract law. She essentially did it as a gift without expectation of the money, and there was no implied promise of payment there as she offered to do it. You may argue that there was implied promise, but it's probably easier in this case to say that there wasn't. So therefore, Janet did not offer good consideration because of the rule past consideration is not good consideration. The key case there is R.E. McArdle. Compare that, though, to this scenario. I've slightly amended it and changed the words. Janet's in-laws ask her to decorate the lounge before they sell the property and tell her they will make it worth her while. Janet decorates the room, her in-laws then sell the property and then tell Janet they'll give her £500 to thank her. 2 months later, they've not given the money and she refused to when she asked. In this case, again, the same thing's being offered. Janet is offering the work she's already done in the past tense as she's completed it in exchange for £500. Again, the most relevant rule is past consideration, it's not good consideration. She's offering work which she's already done, which you can't under contract law. However, in this case, there clearly is the exception of implied promise of payment because they say they'll make it worth her while. So in this case, you'd apply the exception, you talk it through and still explain the rule, but then say what the exception is and say that therefore Janet did offer good consideration in this case. Equally, in terms of performing a pre-existing duty, another popular one in the exam, let's use this scenario. James works in a restaurant. His boss, Dave, asks him and the other 4 waiters to cover the shift between them of a sick waiter. Dave promises to split the wage of the sick waiter between them. It would cost him the same to hire a new waiter for the night. He then refuses to pay them. So in terms of what they're offering, James is offering extra work in exchange for extra money from Dave. The most relevant rule here is performing an existing duty cannot be the consideration for a new contract. So Dave, the boss, will argue that James is contracted to work in the restaurant and follow orders from the boss, so has not offered anything new above his pre-existing duty, and therefore he doesn't have to pay him the extra money. It's unlikely the exceptions of extra element or commercial gain will apply here, as they're only covering a small part of the shift, like in Stilk v Myrick, and it clearly says that Dave's not making any commercial gain as it would cost the same to hire another waiter. Therefore, you'd probably argue in this case that James didn't offer good consideration because he's just doing it's basically following the case of Stilk v Myrick. He's doing a pre-existing duty, which is just working in the restaurant essentially. He's not doing enough to be extra. Compare that those to this scenario, so I've slightly changed. James works in a restaurant. His boss, Dave, asks him to cover the shift of 2 other waiters on top of his own. Dave promises to pay James a bonus for this. It would cost Dave a lot more to hire extra help for the night. Dave then refuses to pay James at the end of the night. Again, James is offering extra work in exchange for extra money from Dave. And again, the most relevant rule is performing an existing duty cannot be the consideration for a new contract. And again, Dave will argue James is contracted to work in the restaurant and follow orders from the boss, so has not offered anything new above his pre-existing duty. However, in this case, James would have a good argument that he has provided an extra element in the fact that he is doing a significant bigger proportion of work, such as in Hartley v Ponsonby, and also that Dave is making a commercial gain because it would cost him a lot more to hire extra help. So he's actually saving money by asking James to do these extra shifts. So you'd apply Williams v Roffey there. So in this case, because the exceptions apply, you would say that James did offer good consideration. So you need to work through those, and I suggest you have a go at some of the practice questions. There are numerous available online on the OCR website as practice questions, and your teacher hopefully will be able to provide you with some of those if you can't find them. And have a go and see if you can work out in the scenarios what the relevant rules are and then apply them in that fashion. Make sure you apply the relevant rule, make sure you apply any exceptions if there are, and generally I would look at it as like, what would both parties argue, and talk it through like that, and then it makes make sure you make sense in the scenario. And particularly with past consideration, make sure you're thinking about past tense and present tense and things like that, and what's being offered and when it was being offered, etc. And of course, make sure you come to a conclusion and answer the question. In terms of the essay, I'm going to go through 10 key points here that you could refer to. You certainly don't have to refer to all 10, but this gives you a good range of AO3 points to make in decent developed paragraphs. Number 1, contract law is about a bargain, not a gift. So if someone gifts you something, then you can't expect to be paid. Equally, that wouldn't be fair. That would deter people from offering gifts in some instances as well, if they were then going to be contracted into that. Equally, the court does need to enforce bargains because if you do both exchange something, we need that consistency. You need the certainty in the law for businesses particularly that they will be enforced. It's a really, really old area of contract law going back centuries, and there's a lot of problems with that in the fact that the law is developed piecemeal, like bit by bit, case by case through common law. There's no statute on this, as you may have realised. We would have talked about one. So one of the big reform proposals here that you could suggest is, of course, that they create a consideration act or a consideration statute laying out the law, which would follow the rules of separation of powers, parliamentary supremacy and that sort of thing, and avoid the issues of judicial lawmaking here and the fact that judges have made all this law. There's also a question as to how outdated it is nowadays as well, which I think I may touch on later, and does all of this apply today, really? Number 2, the courts are very open to what can be classed as consideration, even a peppercorn or a penny, as we discussed. It need not be adequate but must be sufficient. Remember, they're not interested in the equality of consideration, only that there has been some consideration, which you can see in Thomas v Thomas and Nestle v Chapley. Sorry, Chappell v Nestle, actually, it's the way around. And that's really due to freedom of contract. They don't want to get involved in what you're exchanging. If you want to exchange a £500 laptop for a £5, for £5, even though it's worth £500, that's up to you. That's a bad bargain. The courts don't want to get involved, remember, in bad bargains. It's up to you to make those decisions. Tough luck if you make them. But again, the argument here as well is it is a bit silly to insist on a peppercorn exchange, because you are essentially getting it for free, but you're sort of artificially manipulating that into being a contract because you're offering some nominal or value consideration when it's a bit silly, because it is really essentially just a gift. So why can't the court laws just recognise that as a contract still? In terms of 3, talked about this earlier, the inconsistency around exchange of love and affection. White v Blewett said it is not good consideration, but Ward v Byam suggested it was. So there's a range of arguments you can make there around the uncertainty in the law, which leads to inconsistency in different cases making different decisions, as we can see in these two. That then makes it very difficult for lawyers to predict the law and advise their clients, but ultimately it provides flexibility for future courts to make a decision one way or the other. In terms of number 4, past consideration is not good consideration. You cannot do something without expectation of payment and then be offered payment and then try and insist on their payment. So basically, you can't do something for free, someone be nice and say they'll pay for you and then insist they pay you because you did it for free in the first case. But there is inconsistency around implied payment because, of course, implied is a very subjective term. People are going to have different opinions as to whether something was implied or not, and that can create a lot of really difficult, decisions in court as to whether it was implied or not, and it's very difficult to say. Number 5, the inconsistency between pre-existing duty cases and the law. The two cases you can absolutely directly contrast there are Stilt v. Murrick and Hartley v. Ponsonby, both very similar facts, apart from in Hartley v. Ponsonby a much bigger percentage of the crew deserted. So really here the question is, well, what makes an extra element? It's not clearly laid out as to how much extra the element, how big the extra element has to be. It's a fairly vague concept, but it does allow flexibility for the courts to determine in different cases on a case-by-case basis what they think, or what they think is fair, essentially. And we know that Williams v. Roffey added commercial gain, but again, that's a vague concept in the fact that we don't know how much of a commercial gain there has to be, or if it's just sufficient to be like a penny more or anything like that. But it's essentially really making sure that employers don't take advantage of people, and it really is important for workers' rights there, that those cases that they don't take advantage of people and make promises which they then go back on to get people to do extra work. Number 6, consideration may be found where contractual duties are owed to a third party, which essentially means you can be paid to do the same thing by two people, which seems a little odd, but equally the law assumes that people do their research and ask relevant questions, so this shouldn't happen. Equally, if you think about tutoring, you should be able to charge two people to do the same lecture, otherwise you wouldn't be able to do that. And there are a lot of careers, a lot of jobs that require that sort of model of working. So if consideration said that wasn't okay, then that would eliminate those areas of work, things like dog walking and things like that. It might not be possible. Promissory estoppel, you could argue that it's ruined consideration. It's overruled over 400 years of consideration by simply deleting it, by simply saying we don't worry about that, just simply ask have they gone back on their promise. And they did, but and it has done that really, but they did argue that it seemed fair in this case to do this, and it is an equitable doctrine based on fairness. And there's a lot of arguments that the court should be looking at fairness, and that's their job. But equally, is that job, or is their job just simply to apply the law one way or the other, regardless of whether it creates a fair outcome? And you can talk about that, the role of the courts there really, in terms of should they be making fair decisions or should they just be following the law, regardless of the outcome. Number 8, we know that the courts have started to backtrack from promissory estoppel in cases like RE Select Move and D&C Builders v Rees. They've tried to do that quite artificially by saying that the parties haven't acted fairly in those cases, so therefore promissory estoppel is an equitable doctrine. I think that that's kind of a manipulation of the law really to try and backtrack from promissory estoppel, because they've realised that it has overruled consideration in some cases really. But on the essence, they're trying to stop people taking advantage and gaining a financial advantage, like in D&C Builders v Rees, where she did act clearly unfairly, and that's obviously again a fair thing. You could argue that the doctrine of consideration is a technicality, and it simply exists because of how the law's developed historically. And you could argue that it's completely unnecessary, really. Why do we need to consider this? Whether both parties have offered something, does it matter? Quite frequently, it produces what we would describe as rank justice. So, it's not fair. And is it just outgrown, really? That doesn't really apply today. And you can absolutely make that argument. That's a particularly good one for the conclusion or the introduction. And finally, how has it developed and what is the future? Well, it's basically developed accidentally through obscure historical evolution of contract law, really over 400 years or longer. It's not actually that irrational. It's based on old definitions and tests, but it's about the obligation that both parties make something. If you just draw it back to the idea that the law requires a bargain, not a gift, and I think that really ties up the scenario, the sort of essay nicely. And with the essay, make sure that you have an introduction and a conclusion, and go through some developed points in terms of AO3, and of course include as much relevant AO1 as well as you can. Thank you very much. I hope you found that useful. Again, please subscribe to us on YouTube. There's more videos coming out regularly on A-level law, covering the whole of the spec. And please join us on Instagram at Law at Portsmouth College if you're interested more generally on A-level law. Thank you very much.